Commission resumes. You're still under oath, Mr. De Rover. Before the next cross-examination begins, I'd like to ask you a question. When did you tell the National Commissioner that you thought that R5 shouldn't be used in public order policing?
After the 28th of February and before the 8th of March 2013.
2013 or 14?
13. So in the first week of me being here.
Yes, I see. Thank you, Mr. Mr. Semenya's not here, but Ms. Beloy, would you, I don't expect you to give me the answer now, but can you tell me at some stage whether the police have withdrawn R5s for public order policing, not only for, as the witness said, it's not a question of which unit used it, but the exercise in which it should not be used. So would you ascertain and inform the Commission whether that advice that the witness gave the National Commissioner has been accepted and implemented? And if so, the details of such implementation.
I will do so, Chair.
Thank you. Who's going to cross-examine next? Is it Ms. LaRue?
The Human Rights Commission, Chair, yes.
Cross-examine on behalf of the Human Rights Commission.
Correct, Chair.
Yeah.
Chair, in the interests of saving time, my attorney, I believe, has handed to you an index of the new exhibits that we intend to use in the cross-examination, and we've taken the liberty of pre-marking those in the quadruple U series. That's what Mr. Budlander referred to in his cross-examination.
Correct.
But, Chair, there is a further housekeeping point that we do need to address at the start of the cross-examination, which is, as you know, there are a series of videos that have been prepared by a video expert engaged by the South African Human Rights Commission, as well as with CALS in collaboration with SERI for the families. Those videos I intend to use during my cross-examination. I understand that what has been referred to as the commentary, meaning the annotations that appear in those videos, are subject to objection and some dispute by the SABC.
I take it you saw the affidavit that we were presented with this morning,
yes,
made
Chair,
by Johan Libber.
Yes, Chair, we have seen that.
Which was prepared, obviously, on behalf of the police.
Yes. Chair, we've seen that. In the interest of time, obviously I'm happy to address you on the details of all of those, but in the interest of time, we would like to propose that we be permitted to utilize the videos during the cross-examination with the objection noted. And obviously, we will then engage through the evidence leaders with the SAPs to resolve any particular objections that there are to the annotations on the videos. The 5 examples...
How do you do that? I was originally under the impression that the narration was only part of the soundtrack, so you could simply show the videos without that part of the soundtrack. But I understand that's not correct, that there are actually subtitles or super titles, I don't know what the correct word is,
No.
On the screen itself. Is that correct?
Yes,
So
Chair.
which objection is being taken?
There is text that, well, we're not sure exactly which annotations are the subject of the objection. There seem to be a handful of, there are 5 items identified in the affidavit. The majority of those, though, are not relevant because they address apparent inconsistencies with the GW6 series, as well as the Catherine Scott expert evidence. Those are easily disposed of because, Chair, those were prepared when we didn't have the Al Jazeera footage, we didn't have all the SABC footage. So this obviously supersedes that analysis. Any revisions to those documents will be made. But the point here, Chair,
Sorry,
is
let me not interrupt you, but can I put this to you? I understand the objection is being taken by the police. So let's get hear what Mr. Semenya has to say. Are you suggesting, however, that I should allow you to show the video with the commentary and the narration and so forth, even though it contains things to which the police take objection? If that's what you're suggesting, then I think we should hear Mr. Semenya. Mr. Semenya? And then you can obviously reply to him when he's finished. Mr. Semenya?
Chair, perhaps if I describe the nature of the objection we have. Principally, we say commentary like ballistic opinions offered by a non-expert is obviously objectionable. If what he says is something that we all can see, he doesn't have to say it. If, as some of his expertise is to is to make those visuals better readable, then of course we welcome that area of his expertise. But there is commentary there whose facts are in contestation. And that's the nature of the objection we have to the material.
Chair, I wonder if I can give the evidence leader's position on this, because...
Should we finish hearing what Mr. Semenya says first before you give us your position? Yes, Mr. Semenya, are you finished?
So I'm finished.
Oh, you have. I'm sorry, Mr. Chairperson. Please proceed.
I understand that there is a dispute from SABC as to some aspects of the annotations on the videos. Our concern is what is best for the Commission, and will this video evidence assist the Commission to answer the questions that it has to answer? If that's the question that's posed, then the answers are a resounding yes. We regard this exhibit as one of the most important pieces of real evidence that this Commission is likely to see. What it does is it strings together the video streams from various different sources so that one gets a composite picture of scene one. There are annotations which point you to particular things. I would imagine that 90% of those annotations are utterly uncontroversial. There may be 10% which are. The SABC are always at liberty to identify that which they dispute, and they can table their objections. And I would suggest that for today's purposes, Ms. Leroux doesn't refer to annotations in cross-examination that are potentially in dispute. If she wants to point something out on the video to a witness, she can use a pointer and point to it. If it happens to coincide with what an annotation says, well, then one can assess what Ms. Leroux says rather than the annotation. My concern is twofold. The first is that a very valuable piece of evidence, which really, the admissibility of which should really not be an issue. It should be a question of weight to be given to annotations.
I don't understand Mr. Semenya's objection to being against the video as such. And I understand it's a useful compilation of various videos that we've seen, putting things together on the same timeline and so on. I don't understand the objection being to that. The objection is to the commentary, and in fact, even parts of the commentary.
But Chair, can I finish? Because I do have a very serious concern to raise in relation to SABC in this regard, which is that the genesis of these videos, as I understand it, is they grow out of the annexures to Mr. White's statement, the GW6 annexures. And they are a videographic representation of what one sees in GW6. Now, when GW6 was first exhibited, SABC complained that they did not accept it and that it was inappropriate for it to be exhibited through that means. We then started a process. We said, right, let's resolve this. Let's get you to identify the disputes that you have with GW6 and come back to us. We'll try and resolve them. If we can't, then we will have narrowed those disputes and we know what is agreed and what is not agreed. That process started on the 4th of December last year. On the 6th of January this year, we received a document from SABC which was expressly labeled Voorlopige Verslag, which identified a handful, maybe 5 or 6 problems with GW6A, nothing else in GW6. We've been addressing letters to SABC on a regular basis since January this year saying, please tell us what your disputes are so we can try to resolve them. And we received nothing back from SABC. Now, it raises a real difficulty because what you have is a position, and I can see it from Mr. Libber's affidavit in relation to this video. You identify a very narrow range of disputes, most of which will probably be conceded by CALS and the SAHRC. And then on the basis of that, you say, well, let's eliminate the whole thing. And in the process, the Commission is rarely prejudiced at getting to the truth, because what is thrown out and what is a whole lot of material which is of extremely valuable, high probative value, addressing crucial facts for this Commission and not placed in dispute by SABC. And with respect, Mr. Chairperson, if SABC has a problem with this video, it should be asked to identify the particular passages in the annotation with which it takes issue. When it's done so, we can have the fight over that. For present purposes, the video should be shown. Ms. Leroux SABC's rights can be reserved in relation to that. Nobody is prejudiced by showing the video. The Commission is ultimately going to be prejudiced dramatically if the video is not shown.
Chair, as you correctly pointed out, there's no objection in us looking at the video. There is commentary in it. Even if it is 1% that is objectionable, we are entitled to raise that objection.
Have you identified all the parts of the commentary to which you object? Because if you have, you can signal that. I'm not quite sure whether it's possible for that commentary to be excised from what we see before we see it. But the first question is, have you indicated what precisely the points in the commentary are to which you object? That statement to Mr. Libbo that I read talked about some points, and then I think he raised half a dozen or so. But it was only some. It didn't purport to be a comprehensive and complete list. Now, have you got such a thing?
Chair, I may produce it in due course, but I can indicate even now, if I understand what the narrative is to that documentary, it now even says what we say was 8 seconds of shooting in scene 1 is now 12 seconds. And I don't know whether I'm able to accept that narrative like that from some cinematographer. And that's one of the illustrations that we have difficulties with.
Is it not possible for you to commence your cross-examination? I take it you've got a lot of other cross-examination material, to have a session with the police, perhaps during the lunch hour or whatever, to identify the bits to which they have specific objection. I don't think we should spend much time on it further at this stage. Rather spend non-sitting time on it outside the chamber, you people can. If an affidavit is put up, one can't knock out the whole affidavit simply because one paragraph is not appropriate. That paragraph can be struck out. But the way we're doing it at the moment, it's obviously important we should see the actual videos themselves, even possibly without commentary. But the trouble is, I understand the commentary is not just part of the soundtrack. It's on the screen as well. So is there a solution that you can suggest whereby we can deal with the problem but not waste any further time, and you can cross-examine the witness on other matters in the meanwhile? Because I would imagine there must be quite a number of other matters. I'm not wishing to minimize the importance of the video. It sounds a very important thing. But are there not other matters you can deal with in the meanwhile?
Unfortunately not, Chair. So the proposal I make is that we will certainly engage through the evidence leaders with the SABC on the specific annotations that they have objections to. The one Mr. Semenya just mentioned has never been raised with us before this. The overwhelming majority of the annotations are simply things like, Inyala 4 reaches the kraal, or this is the single pylon. So I'm sure the overwhelming majority of the annotations that are there to assist the Commission. And Chair, I must pause there because at great expense, this exercise has been undertaken because we've had repeated requests from the Commission, Commissioner Hemraj in particular, suggesting that a chronology that compilates all of the available footage. Mr. de Rover talks about the use of independent, auditable, objective evidence. That is what this does. For the tiny handful of quibbles that we may have on annotations, we'll deal with those in due course and not take up any more time in the Commission process today. So my proposal remains, we note the objection, we will undertake a process that may result in concessions or revisions or something that will be provided to the Commission once that process is completed, and subject to those qualifications, the videos can then be used in closing argument, and if the Commission finds them helpful, referred to in the report. But for today's purposes, if we just note that these are subject to a process, but that we are permitted to use them as the way we plan to. And then we will certainly engage in that process to try to narrow the questions of dispute. So to go back to the 5 examples listed in Mr. Libbo's affidavit, 2 of those refer to inconsistencies with earlier documents that didn't rely on the same universe of information. Those are easily dealt with. One refers to a conclusion reached on the video that seems to be an absolute explanation to that part of the video. It relates to the flight of rubber bullets and rubber balls. We're told by Mr. Libbo that, in fact, that's the plastic wad, the jacket on that ammunition. That may well be the complete answer to that part of the video. We would then obviously accept that explanation, and that would be that revision. The first example refers to the description of the direction in which the strikers are moving. That's an easy revision. And the final one relates to the animation that has been done that shows the Inyalas and the movement of the lead group. It notes at one point at 15 seconds into the video that it claims the lead group positioning is wrong, but by 50 seconds into the video, they accept that it's now correct. These are the minor revisions that would be required on what we now understand to be the areas in dispute. I should also then just place on the record that our own review of the videos has highlighted 2 points of errata. We've engaged with our colleagues from SERI who've collaborated with us on this. Perhaps they also need to have an opportunity to address you on this. There are 2 minor errata points that we've picked up already from that, which is in Exhibit V2, which is the video that shows the movement of the strikers. 22 seconds into that video, it refers to the strikers visible walking off the Kopi towards Nkaneng. That needs to be revised to say towards the west. At 3 other annotations, 2021, 2145, and 2211, it speaks about the northwestern edge of the kraal. That needs to be the northern edge of the kraal. This is the extent of the revisions that need to be made. And therefore, in light of that, and with the undertaking that we'll deal with any specific annotations that cause the SAPs some concern, if we could be permitted to use the videos today as we had planned, in order to assist the Commission.
Thank you. Mr. Bezos, your light's on again.
Mr. Chairman, we want to make a submission in relation to the objection raised by SAPs. They themselves went to a lot of trouble to comment on the photographs. Could I use, so in support of the conclusion that I'm going to make, have a look at page 194 of Exhibit L.
Slide 194. It's one of the examples where the police chose to comment on the photograph and put colors in and things. But may I read the printing? In the following slides, 3 separate organized attempts will be portrayed where protesters approach the police line. That's comment. I am assume, Mr. Chairman, that the witness will have been shown Exhibit L before he was asked to comment in writing as to what the police case is exhibited in Exhibit L. We didn't object to that, Mr. Chairman. I don't know what influence this comment had on the conclusion that was arrived at by the witness in the witness box. But we didn't object. But now for them to say that any commentary is prejudicial to them should not be upheld. The SAPs can accept that the Commission will be able to come to a conclusion what is evidence and what may be the expression of an opinion. But these opinions in Exhibit L, we have no doubt, were made available to the witness before he made a conclusion exculpating the police. It would be manifestly unfair to prevent those who do not accept the police version if any portion
of the video was excluded.
Regard to Exhibit L, who was responsible for the captions? The comments that you refer to were contained in captions, were they not? And they were contained also, I suppose, in things like coloured arrows and so forth superimposed on the photographs. So who was responsible for those things?
Well, Exhibit L was put up by SABC.
The question is that my understanding was it was Lieutenant Colonel Scott and Colonel Visser. I think he was a colonel, I'm not sure what his rank was. Scott did give evidence, Visser didn't. Now, I think I'm correct in saying that most of the captions were the work of Visser, am I right?
Certainly a substantial number. In the cross-examination of Colonel Scott, Chairperson, there were a substantial number of issues on which he was questioned in relation to Exhibit L, which he identified as not being his responsibility, but Colonel Visser's
So what you're
responsibility.
effectively saying to me, Mr. Bezos, is what sorts for the goose is sorts for the gander. If the police can put up a presentation which contains captions which are opinion, not backed up by a witness who's able to defend them, then the same should apply to the Human Rights Commission. Is that your submission?
Mr. Chairman, thank you. This is, I wish that I had expressed it
Flattery
as
will
well.
will get you nowhere.
But that is precisely, Mr. Chairman. But we are going to argue that an important matter in relation to the witnesses, this witness's evidence will be, was he told the whole truth, or was he influenced by the material in Exhibit L and other matters?
I understand. What
we
you're saying
hope
is he
to
didn't...
persuade
Yeah.
the witness and the commission that he was not told the whole truth before he made.
What you're
that,
saying is that he's endeavouring to be an impartial witness, conscious of his duty to the court to be an the commission to be an impartial witness. Your contention is that because he's only heard one side and he hasn't heard the other side, his evidence is defective for that reason, and you're trying to remedy that. Is that your point, basically? No, I understand you correctly.
Mr. Chairman, I don't understand why my learned friend Mr. Semenya and his team are so concerned that if it's pure comment, not supported by the video, it will be ignored.
It's like Mr. Visser's stuff in Exhibit L.
Yes.
Yeah, right.
So
What do you say about
I urge,
that?
Mr.
Yes,
Chairman,
yes.
that these videos should be shown. They are very important for the final decision by the witness, Mr. Chairman, by the witness as to whether he was fully briefed by truthful evidence at the time that he made his two statements exculpating the police.
Yes, thank you. Yes, I think I have that point. Mr. Semenya, how do you deal with the source for the goose, source for the gander point?
Can I make 3 points, Chair? Very short 3 points. We are saying the video material must be shown. So that should put that aspect to bed. What Mr. Bezos is referring to here as Exhibit L, we have had evidence of that. Whether it is accepted later or not, it's a different matter. There is no intention of calling these witnesses to support that narrative which they are making. That's distinctly different. But may we propose a solution, Chair? Let them show it with all that narrative that it has if you give us the assurance. Aspects of which are not supportable because one does not qualify as an expert to make it, we'll ignore them. Aspects to which are references to things that we also can be able to watch and not agree with, would have an opportunity to discuss or argue their weight.
Right. We'll give you the undertaking that you asked for. It will apply also, of course, to those parts of Exhibit L, which, with the work of Mr. Visser, which may also not be capable of being supported. So on the source for the goose, source for the gander principle, it can go in, but subject to that very important caveat, which you've expressed, and the undertaking that we've given you. You've got to move from here if you're going to show the video, because it'll be shown behind our backs.
No, Chair, for two reasons. Firstly, because all the cabling in the room has now been replaced to be high definition. So even your screen, if you'd like to watch the big screen, you can.
No, but the problem is we sit here looking at our screen, we've still got this powerful light in our eyes.
Yes.
Now,
Chair,
maybe you can handle that sort of thing, but I feel I can't. So,
but secondly, Chair, I'm not. The plan of my cross-examination, the videos I don't start with the videos. They come a bit later.
When you start with the videos, let me know.
Yes.
So I can prevent myself being blinded by the powerful light of your projector.
And of course, Chair, there's a related issue, which is the videos obviously deal with scene one, and so there is a lot of footage that may be upsetting. So a warning would also be required for all the videos.
When we get there, I'll delegate to you the task I normally perform of giving a warning to those who may be caused emotional stress and grief by looking at the images that are going to be on the screen. Will you do that for me when we get there?
Yes, Chair.
Thank you.
Right, now we can start. Good morning, Mr. De Rover.
Good morning.
Mr. Rover, I'd like to start with, in your statement, FFF11, page 2, paragraph 6, you claim public international law of human rights and humanitarian law, particularly as it relates to armed forces, police, and security forces, as one of your areas of expertise. You've also testified this morning about the academic qualifications you hold relating to international law. When, during the engagement with you by CELS, we have asked you a question, Chair, I'm going to try to move through the evidence without us having to go through the documents. I'll summarize them and give the references, but given the time constraints, I'll try to do that as soon as we can.
Has been given notice the document you're going to rely on.
He has indeed.
There's an opportunity to look at them. So
Yes.
you can summarize them. The witness won't be at a disadvantage, and if he feels he is, I'm sure he'll tell us.
Yes. And Mr. De Rover, of course, if I'm referring to a document you're not familiar with, let me know and we can place it before you. In the May 2014 interrogatories posed to you by the Human Rights Commission, you were asked whether you accept that an assessment of the lawfulness of police action that results in numerous deaths requires an assessment of the planning, briefing, deployment, and command of the operation as much as a consideration of the actions of individual officers. We then noted that in this respect, the South African Human Rights Commission trusts that Mr. De Rover is familiar with the European Court of Human Rights case of McCann versus the United Kingdom and other similar authorities. Chair, that is page 2, paragraph 3A of the interrogatories. Your response to those in June of this year stated, jurisprudence of regional bodies such as the European Court of Human Rights may, in some limited circumstances, indirectly contribute to the emergence of new international legal norms, although they will never on their own generate such norms. To cite judgments of the court in a way that implies their direct legal relevance to South Africa is disingenuous. As CELS must be aware, those judgments impose no legal obligations on states that are outside the European human rights system. The findings of the McCann case may well be of academic interest to the issues at hand, but have absolutely no legal relevance to the Commission and its work. You recall that response?
I do.
Now, what I'd like to do is move away from the question of the relevance of the McCann judgment to South African law, because obviously we accept it's not a binding precedent. I'd like to ask you whether you are familiar with the principle in international law of prevention or precaution. Are you familiar with that principle?
In what context?
In the context of the use of force.
Yes.
And Chair, if we go to what's been marked quadruple B8, because it was referred to by the SABC in their cross-examination of Mr. White, page 93 of your bundle, that is the UN Special Rapporteur's report, which notes that its intention is to discuss the protection of the right to life during law enforcement, making a case for the need for a concerted effort to bring domestic laws on the use of especially lethal force by the police in line with international standards. That's the cover page, the summary of...
The cover page is 93. What page is the actual report you want us to look at?
Chair, if we can then go to page 10 of that report. There it lists the requirements for the use of force. And, Chair, in particular, it's A, B, and C there, sufficient legal basis, legitimate objective, and necessity. If I could then ask you, Mr. de Rover, to direct your attention over the page, 11, to paragraph 63. This is the precise paragraph that Mr. Semenya put to Mr. White, where the Special Rapporteur sets out that there is the often overlooked requirement of prevention or precaution. It's explained as once a situation arises where the use of force is considered, it is often too late to rescue the situation. Instead, in order to save lives, all possible measures should be taken upstream to avoid a situation where the decision on whether to pull the trigger arises, or to ensure that all the possible steps have been taken to ensure that, if that happens, the damage is contained as much as is possible. The following paragraph sets out that the failure to take proper precaution in such a context constitutes a violation of the right to life. In the McCann case, the European Court of Human Rights held the use of lethal force by soldiers who erroneously but in good faith believed that a group of terrorists were about to trigger an explosion did not violate the right to life, but the lack of control and organization of the operation as a whole did violate that right. Now, you'll agree with me, of course, that what the UN Special Rapporteur is doing here is setting out principles of international application. They're not parochial or regional. It's an international principle identified. Sorry, a nod of the head can't be captured for the transcript.
Though the proceedings are being televised, or the television cameras are here, those will not be preserved for us. When we go over the evidence, we'll read the transcript. The transcript won't have your body language that you nod at your head. So if you want to say yes, you must say yes, and you must do what I sometimes fail to do, and turn your microphone on to make sure that the word yes is recorded.
On that point, I'm already leaving it on constantly so I don't forget. I have no objection to you framing the subject as you've just done.
Thank you. And then, Mr. de Rover, in that context, as an international principle, and irrespective of the status of the McCann decision in South African law, would you agree with me that the principle of prevention or precaution is an established principle of international law applicable to the use of force?
You know, Chair, there's a problem with these principles in international law, exactly with the fact that they are principles. And I always have to pull the rabbit out of a hat when I teach police, and depending on where I am, I even have to refer to regional instruments and try and tie them into the right to life and the obligation for the state to protect that right, and not just by enacting law, but by actually being more proactive than that. And maybe in that connection, because I understand your reference to McCann, and if it's with the caveat that you gave, I have no problem that it exists as a reference, and I would actually like to add to that Osman versus the UK, because that is a case that may then in its findings have a relevance that you actually seek, in that it addresses this issue of duty of care, where if you have a particular set of circumstances where it is foreseeable that somebody is going to become a victim of crime, you, as a state responsible, have a duty of care. So you must then take steps to protect these people. If you want me to link that to Marikana, then, for example, you can hold that as the incident develops, and I'm talking 10, 11, 12, and deaths occur, and people are put at risk, and it is actually quite clear that people of a particular organization become a target, and that it's foreseeable that more of them will become a victim, then there is a duty on the police to take measures that seek to protect. So if you see the increased VISPOL measures that SABC implemented around Marikana, they are an utterance of that. I have to stress that the European Court gave quite strict criteria for when that duty of care occurs, and you'd obviously have to measure them to what exists under your own national laws in that respect. But it is an addition, and it's an operationalization, if you will.
Right.
That was the point I wanted to put to you, and that is, it seemed to me that you, I'm not being critical, but you may be venturing a little bit into a field in which you do not belong, if I may say that. We are concerned, obviously, to state as far as we can what we think the domestic law of South Africa is in relation to these issues. The decisions of international tribunals would obviously are not binding on us, but they might be used in appropriate cases as a source of persuasive material.
Yeah.
And judges in South Africa do that.
Yeah.
They use comparative material. There are also provisions of the Constitution, of course, which deal with how you use international legal material, as it were, and comparative material of other jurisdictions. And there are problems about what is used cogens and what is not, but we won't go there now. But just confining ourselves to the domestic situation, the South African courts would look, if it was appropriate, to decisions of a tribunal such as the European Court of Human Rights in search of, not binding obviously, but persuasive material which would guide us to apply the right principle if our law hasn't got clear authority on the point. So that's the first point. So you mustn't tell us that McCann's case isn't legally binding in South Africa. We know that. But you also can't tell us, and I don't think you are trying to tell us, that we can't look to it for persuasive material and how to decide some of the issues that arise here. But the second point is, we already have domestic authority for the proposition that you've just referred to. We had a case some years ago which eventually went up to the Constitutional Court and then came back to the Supreme Court of Appeal. I was in that case, where a woman brought a claim against the state because she was raped by someone who had been released on bail in circumstances where it was foreseeable that if this person were given bail, he was likely to go out and commit further crimes. She was the victim of one of those further crimes. So that's already the law of South Africa. That was laid down by the Constitutional Court. And so that principle we already have as part of our domestic law. Yeah. But in the search for persuasive authority, in matters not covered directly by our domestic law, we certainly look, that's one of the, if I may to put it this way, one of the glories of the South African legal system is we have tried consistently for many, many years to approach the matter in that way, look for persuasive authority elsewhere if we haven't got adequate provision or case law on the matter in our own law. And so that, I think, is important for me to tell you that, because that is effectively what underlies this whole debate about whether McCann applies and so on. Again, even if the principles are accepted to some extent or entirely, we may disagree on the facts, whether you will remember there was a dissent in the McCann case. We would be able, if we considered it appropriate, to pick the dissent rather than the majority if we found the dissent to have more persuasive force. But the inquiry is not limited to domestic materials. We certainly look at international materials, and we are obviously also encouraged by our Constitution to do our best to ensure, without even getting into use Kogan's problems, to make sure that our law is consistent with the international position as well.
Chair, let me then apologize if the way I phrased myself led you to believe I was disagreeing with you, because the opposite is true. I was agreeing with that proposition. The next thing, I think that acknowledging this part, there is actually existence of, if you take the basic principles on the use of force and firearms, they clearly set out those requirements. and they are most commonly voiced in terms that you must attempt non-violent means first, and if they seem unworkable and your lawful objective is that important that you still want to pursue it, you must try less extreme means first. So I'm totally acknowledging and in agreement with what you say.
Thank you, Mr. de Rover. Then, turning to precisely that context.
Sorry, just put one other point. You spoke about the duty of the state, the law, to protect innocent people. The law actually goes further than that. It says even a criminal, even an assailant, is entitled to his right to life unless it's, to use the expression used by the bridge players on the Constitutional Court, unless it's trumped by something else. Yeah. And that is that even a criminal who's attacking somebody else has a right to life, which can only be infringed if the circumstances are such that there's no other alternative. And that's something which is, as you may know, become more, it was always the law, but it's become more relevant since we have a constitution with an entrenched right to life. And of course, our entrenched right to life is in pari materia with the right to life in international instruments such as the European Convention.
Chair, I've spent 22 years of my life now in the field of police and human rights, and I can only echo that sentiment. There are too many realities where it's thought that criminals shouldn't have human rights, or that to bind police to observing those, that is unleveling the playing field because the other side is not playing by those rules. And I totally disagree with that. The norms and the standards and expectations are clear. And as officials of the state, you are bound by them, and you are supposed to uphold them.
Mr. de Rover,
Sorry, Mr. de Rover, I had a conversation with witness, but I hope it was of assistance to us all.
I'm sure it will be, Chair. Mr. de Rover, in the book that you were the author of the first edition, To Serve and Protect, you referred to it this morning as a very important reference work. I'm assuming you approve of the second edition, the update that was made to your initial text. You don't disagree with anything that was revised in the second edition?
If you did a text comparison, there's I think, close to 90% overlap with the first edition. So it's updated to meet current existing requirements in terms of case law, applicable treaties, new treaties that have come into force. But on the fundaments of the topics as they relate to police task, organization and responsibilities, powers and duties, I think it's the same book.
Right. Chair, for the record, this is quadruple U3, which is an excerpt from To Serve and Protect. In particular, it's Chapter 7, the use of force and firearms. Now, Mr. de Rover, one addition that we have been able to identify from your first edition appears page 259 of the typed page in that chapter, which has been provided to you. It's page 86 of the bundle.
The book that's gone into this book has gone into the second edition.
Yes, Chair, this is the second edition.
This is from the second edition.
This is from the second edition.
Can you bear with me for a second while I get it on my screen, because I have the PDF, but I can't find it in my folder.
Sure, it's also on display on the screen next to you.
I'm sure you'd find it easier to have it on your screen.
Thank you.
So on page 259 of that document, no, page 259, printed page.
86 of our bundle, 259 of the document itself, and the document is now an exhibit, quadruple U3. 259.
Yes, and if we could go down below that block that's shaded integration in practice, there we see the text. This is in the context of integrating into training and the like. This principle, it said, the author's right there, depending on the complexity of a situation, responsibility does not merely lie with the individual law enforcement official at the location. The higher command level has overall responsibility for taking all precautionary measures in line with the provisions of the basic principles for the use of firearms in order to respect and protect life. In the box below that, we see, again, the McCann case cited as that principle. So taking the general principle into this context of use of force and firearms in policing operations, would you agree that there is a generally applicable principle in international law requiring those in command of a policing operation in which higher levels of force are anticipated as a possibility to plan and command those operations in such a way as to minimize the risk that lethal force will be used?
It goes to the heart of accountability. And I actually would contend that that does not limit itself to organized police operations. In fact, it's about every police contact with the public. There is a possibility to invoke command responsibility, because if a single police officer in a single contact with a citizen does something that is unbecoming or unlawful, and if there is reason to believe that a superior officer was aware of that and could have done something about it, that responsibility exists. And of course then by consequence your proposition is true, and I agree with that.
Right.
Mr. LaRue, when you reach a suitable stage, I'd like to take the second German, but the tier German, but obviously you must tell me when it's appropriate, so I don't want to break into your cross-examination unnecessarily.
Chair, we may as well take the adjournment now.
15 minutes.